Hey everybody, this is Eric Niederlander with Trusted Elder Law and Asset Protection. We are an estate planning and elder law firm based in Pensacola, Florida, and I'm licensed to practice law in the state of Florida and Alabama and can serve clients across both states. Today I want to talk to you about a revocable living trust and what that does and how it can protect you and avoid probate once you pass on. So a revocable living trust can be thought of as a fancy will. And basically the trust is created and then you retitle all your bank accounts and property into the name of the trust. And we do that because the trust will live on forever and we don't. So that's how we avoid probate, because the trust doesn't die. And we name successor trustees to carry out the terms of the trust once we pass on or become incapacitated. One of the nice things about a revocable living trust is if you do become incapacitated, whether that's a short-term incapacitation, like you're in a coma or something, or a long-term incapacitation or permanent incapacitation due to dementia or Alzheimer's or something along those lines, then instead of your family or friends having to go to court and getting a guardianship over you, the successor trustee is able to step in and manage the assets that are in the trust. And then we'd have other supplemental documents like a durable power of attorney and healthcare surrogate that would take care of financial matters that aren't trust related, and healthcare matters. There would be somebody to make healthcare decisions for you if you're unable to, therefore avoiding the need for a guardianship. The revocable living trust, you have the same control and access to your assets that you did prior to creating the trust. It's just a superficial name change that allows the successor trustee to step in and manage the assets when you become incapacitated or when you die. That avoids the probate. And so you can amend the trust, you can revoke the trust, you could do it every day of the week if you really wanted to. So you don't lose control of your assets, and the standard revocable living trust isn't a creditor protection trust, it's just a probate avoidance trust. There are clauses that we can put in to protect your loved one's inheritance from creditors and divorce and things like that. A lot of times people tell me, I don't need a trust. I've got my kids jointly on my bank accounts, or everything's payable on death to my kids and or my spouse or whoever. And, so I'm avoiding probate that way. And that's fine and good. But if you have accounts out there that aren't jointly titled, if you become incapacitated, then they're going to have to get a guardianship over you to get access to those funds and manage them while you're incapacitated. The payable on death wouldn't kick in because you're still alive. Also, if you have your children or whoever jointly on those accounts, they're the owner of that account. So if you have multiple kids but only have one child on the account as a joint owner, when you pass away, they become the sole owner. And if you want them to share it with their siblings, well, it's their money. They may or may not share it. Need to have that talk with your kids. But also, if your kids get divorced, that could be a marital asset that the spouse could try to get some or all of. If your kids have to file bankruptcy or get sued by creditors, then that's an asset of the bankruptcy, or potentially the creditor, and that account could get garnished. Regardless of whether they put money in that account or not, they could also, go to the bank, write a check for the full amount and head on to Vegas if they wanted to, because it's their money just as much as it's your money. So you really have to be careful about who you put on as a joint owner. Whereas if you had everything titled in the trust, you could even have your child as a co-trustee and get them on the accounts as a co-trustee, and they wouldn't have any ownership interest in the account, so they could be sued or file bankruptcy or whatever, and that's not going to affect your money because they don't have any ownership interest in it, while you're alive. Also, the trouble that can happen with having everything payable on death to your kids or whoever comes when somebody dies out of order. So if you have your son or daughter, and you only have one son or daughter, and they're named as the beneficiary, and they pass away before you, and then you forget about naming somebody new as a payable on death on that account, then that's going to create a probate and create issues there. Also, if you're naming it to a minor, that's going to create a probate. Or if somebody is on some type of means-tested government program like Social Security Disability or Medicaid or something like that, and you leave them, you make your bank account that has $100,000 in it payable on death to them, well, they just got $100,000, and that's going to kick them off their government benefits. And in that scenario, $100,000 is a good chunk of change, but it's not going to be enough to last them a lifetime. They're going to still need those government benefits, so then they have to protect those assets and do some planning to maintain the government benefits and receive the benefit of what was left to them. So proper planning is important. A lot of times people say, I don't need a trust, I just need a will, or I don't need estate planning at all because I don't have anything. Well, those are the people that need to plan the most because they can't afford to make a mistake. And, with some simple documents and proper planning, we can avoid the costs of a probate and other mistakes that may happen. And, just get your affairs in order and get everything situated because, we're not guaranteed tomorrow, so we never know what may happen. So if you're interested in a revocable living trust or other estate planning, give me a call. I can be reached at 850-607-2222 or toll free at 855-ELDER-FIRM, and it can be found on the web at trustedelderlaw.com. So again, my name is Eric Niederlander. Reach out if you're looking for estate planning, and I look forward to hearing from you and seeing how I can help.